This has the potential to cause a national crisis if the Supreme Court actually does agree with Ottawa. All hell is going to break loose, and it's going to break loose rapidly.
Sean Fraser's track record as a minister is a dumpster fire at best, but he seems intent on outdoing himself and all other Liberals as he's on the verge of causing a national crisis. With one stroke of a pen, he has threatened to single-handedly collapse the Constitution, hand all legislative authority to the courts, and unite all the provinces against the federal government.
Let's take a look. So, ladies and gentlemen, this is our precious Canadian Charter of Rights and Freedoms. This came into effect in 1982 through the Canadian Constitution Act of 1982. And in it, it outlays, 34 different sections that goes over what rights and freedoms that we're supposed to all have. Why are we showing you this? Well, because there is a specific section that we need to talk about. Zooming in on the far right, we go to the section that deals with the application of the Charter. And the section that we want to really pay attention to is Section 33.
1. Parliament or the legislature of a province may expressly declare an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate notwithstanding in provision included in Section 2 or Sections 7 to 15 of this Charter.
So what does that mean? Well, what it means is that what this allows a province to do is it allows the province to put in an act of the provincial legislature that could possibly contravene one of the sections in the Charter. Why would this be the case? Well, one of the reasons for this is so that it maintains the separation of power between the provincial governments and the federal government, and it also acknowledges that each province has different cultures, different peoples, and different ways of actually doing things and different needs. So this is really where this comes into play, because when the Constitution Act was actually being discussed, when Prime Minister Trudeau was actually trying to put it through in 1981 and 1982, there was a big concern from the provinces as to how much power that they were actually going to be having once this was in place. British Commonwealth operates under the premise that Parliament and the legislative bodies are supreme. Why is that? Well, it's because it relies on this fact that the average person, the average Canadian, are electing these people to actually represent them in Parliament, and therefore those are the people that should have the real power in what laws are actually created and enforced in the land. If you don't have that, and if you end up handing that power over to unelected people, then things can go south very, very quickly, because the general public has no means of actually dealing with that, because you cannot vote out a judge. You can't vote out police officers. You can't do anything like that. But you can vote out a government, and you can vote out a member of parliament, provincial parliament, a municipal government, etc. So that's why there was actually a big fight back then. And it's actually one of the reasons why Quebec was the only province to not sign the Charter of Rights and Freedoms and endorse the Canadian Constitution Act, but it applies to them nonetheless. And there's a specific clause in the Constitution Act that really made everybody nervous.
Section 52(1) of the Constitution Act of 1982, the Supremacy Clause. Provision. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Purpose. Section 52(1) recognizes the primacy of the Constitution. It imposes an obligation on bodies empowered to determine questions of law to do so in a manner consistent with the Constitution and to invalidate or treat as invalid a law to the extent of its inconsistency with the Constitution.
So what does that mean? Well, basically, this is near the end of the act, and what this says is that any laws that the federal governments or provincial governments may end up enacting and creating must apply to the Constitution. Otherwise, the courts can deem it invalid. So this is the clause that was really causing a lot of problems when there was negotiation between the federal government and the provinces during the implementation of the Canadian Constitution Act. Now, none of these clauses were numbered at that point. They were just being drafted. So if you're confused why this is at 52 and the other one we're discussing is 33, don't worry about it because they were numbered after the fact. The point is that this section 52 was actually in one of the original drafts of the Constitution Act, and section 33 was not. Section 33 was added after the fact when the provinces demanded that they needed that in order to ensure the supremacy of the legislature and also allow the fact that the federal government and judiciary couldn't interfere within provincial affairs. There's obviously overriding powers when it comes to federal law and the criminal code and things like this, but the provinces wanted to be able to have their own legislature and make their own laws as applicable to their province. And recognizing that it may not actually apply to the rest of Canada, this is where Section 33 comes into play. It's their shield against the judiciary and the federal government from overreaching and coming into their playground, as it were. So how does this apply to now? This is the separation of powers within Canada. You have the three branches.
So at the top, we have the judiciary, power to make judgments on law, and that's in red. And then on the right, in purple, we have the executive government, which has the power to put law into action. And then in the lower left, we have in blue, parliament, which has the power to make and to change law. So these are the three pieces of government or three branches of government, and they combine to form a whole in terms of making and enforcing our laws.
That brings us to Bill 21. What is Bill 21? Well, this is a provincial law that was actually passed in the Quebec government, the provincial government. Bill 21, also called an Act Respecting Electricity of the State, was passed by the Quebec National Assembly on the 16th of June 2019. The purpose of this legislation was to confirm the province's secular status as well as to prohibit the wearing of religious symbols by civil service employees in positions of authority and by teachers in the public sector. The legislation does not apply to training teachers and includes a grandfather clause for those employed prior to the passage of the new legislation. So what this law essentially says is people of Jewish descent cannot wear their head attire. People that wear turbans, you can't do that. People who wear burqas, people who wear hijabs, and it goes on.
Does it even include Christians who want to wear a crucifix necklace, for example?
So you wouldn't be able to show it. All religious symbols would not be able to be shown. And their rationale, whether you agree with it or not, and we're not taking a position on that today, is that if you're going to be a employee of the state, then the state should appear as neutral as possible, which should remove all forms of signaling what religion you may or may not belong to. So this is the whole point. And you notice at the end, it says that if you were already an employee and you are wearing this religious garb, you are allowed to continue to do that as grandfathered in. But for new employees, so they understand going in, that these are going to be the restrictions. Well, after this was actually implemented, you can imagine that there are many organizations that did not like this, which led to the court challenges and where we are today. So, although Ottawa is not one of the people that is actually appealing this law, they are registered as what's called an intervener. And what that means is they are registering as a party that wants to provide a perspective on why or why not that this particular law should be upheld or should be struck down. And this is where things go south very, very quickly. Because Sean Fraser put this statement out the other day.
As Attorney General of Canada, I have filed a factum with the Supreme Court of Canada outlining Canada's position on constitutional issues raised by the use of the notwithstanding clause. The Canadian Charter of Rights and Freedoms is a pillar of our democracy and a reflection of our shared values. It guarantees fundamental freedoms, including freedom of thought, belief, expression, religion, and association. It also guarantees equality before the law and the right to life, liberty, and security of the person. The Charter protects these rights for everyone in Canada, and they are at the heart of our democratic society. This case is about more than the immediate issues before the court. The Supreme Court's decision will shape how both federal and provincial governments may use the notwithstanding clause for years to come. As the court considers this case, Canadians can count on the Government of Canada to defend the Constitution, respect their rights and freedoms, and to stand up for the Charter that protects them. Well, I certainly don't agree with that, because it was the Liberals who suspended our rights during COVID.
Right, so for Sean Fraser to sit here crowing about the fact that the Charter is so important and we need to protect our rights and et cetera, et cetera, et cetera, give me a freaking break.
Well, and what about this Bill C-9 that they just introduced against hate symbols? We haven't dug deep into it yet, but we will. And I mean, that is against people's freedom of expression.
Right, and you talk about Bill C-2 that wants to infringe on our privacy and our right to write what we want in mail and having to rely on a warrant to actually give organizations access to any of that information. So Canadians are not buying this at all. But before we give our take on this, we want to give you a little look, because many legacy media outlets have actually put together articles on this, and they talk about this factum, but as per normal, nobody was linking to it. And it was very, very difficult to find.
Well, that's why they were linking to it.
That's probably why they were linking to it. But we were able to actually find it, as well as many, many others. And what is a factum? Factum is essentially a document. Basically a document that you put in with all of your arguments as an intervener, and you say, this is what I think, and this is why, and yada, 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 yada. But Sean Fraser didn't link to it. The legacy media didn't link to it. But we will link to it. You can find it in the description. Here's one of their arguments here. So it says the use of Section 33 cannot result in irreparable impairment of the rights and freedoms guaranteed by subsection 2 or 7 to 15 of the Charter. Section 33 is subject to a second constitutional limitation. It cannot be used to cause an irreparable impairment of the rights and freedoms guaranteed by subsection 2 or 7 to 15 of the Charter. That is, an impairment that prevents these rights and freedoms from regaining their full normative force once the Declaration expires. This limit refers to the impact or right or freedom itself in its general and normative scope, rather than et cetera, et cetera, et cetera. So what are they trying to argue there? Well, what they're trying to say is that if a body, province or otherwise, uses Section 33 and it's going to cause an irreparable harm to a right that is already granted under the other sections of the Charter, then you're not allowed to do that. Except the whole point of Section 33 is to allow the province or the body to implement a law regardless of those other sections in the Charter. That's the entire point of Section 33. So in a way, they're trying to say, well, understanding that that was the whole intent of Section 33 being put there in the first place, you're not allowed to do that. So that's what they're trying to say.
So basically, we put this clause, Clause 33, or the notwithstanding clause, into the Charter for you to use in this specific case, but you're not allowed to use it in this specific case.
Right. And what Bill 21, which is what's under attack here, is saying is, it's not saying that you're not allowed to practice the religion of your choice, and it's not saying you're not allowed to wear whatever you want. outside of your state duties when you're employed by the state. It's just saying that any new people that are considering working as a teacher or in the civil service, you're not allowed to wear any of that religious attire. Again, you could agree or disagree with that. We're not taking a position on that today. But when you're talking about the Charter and the Constitution and the powers and the separation between those powers, this is where it becomes very important, because we have a federal government, and much of it is the same, that implemented the Emergencies Act that caused irreparable harm to the rights of Canadians at large. And especially because the fact that they seized money from bank accounts, they went after people that donated to the Freedom Convoy, and you have two people that are waiting for sentencing, which is a violation of their right to free assembly and their violation of right to free expression. So they're trying to have their cake and eat it too. But we'll come back to that in a minute. So this is one of the main cruxes of the government's argument. We're not going to go over the whole thing, but essentially what this says is it says that the courts have a responsibility to review any invocation of Section 33, the notwithstanding clause, and that if the courts find that it actually does, quote-unquote, violate the Charter or the Constitution, that the courts have the ability to actually strike it down. Why is that important? Because what this essentially does is it makes Section 33 completely pointless. It removes the freedom of the provinces to enact laws that they believe are actually viable and are particular to their part of the nation. And it actually makes those invocations of Section 33 subject to the courts, not the provincial courts, federal courts, and Supreme Courts. Why is that important?
Well, because then, again, you've got Ottawa reaching its hand down into the laws of the provinces and telling them what they can or can't do.
And that's because Ottawa picks the judges that actually sit in the federal courts and the Supreme Courts. So if Ottawa didn't like some of the legislation that the province actually implemented as a result of enacting Section 33, their handpicked judges could say, yeah, I don't like that. Goodbye.
Yeah, we're going to overrule it. And then you have a case, if we go back to that chart with the three different branches of government, where you've got the judiciary overruling what the legislative assembly, or in this case it says parliament, but the provinces are saying. You have the judiciary saying, whatever you've written down doesn't matter. We're going to overrule it.
Right. And the other very alarming issue with this is that you could see a scenario where you are now giving the judiciary the ability to override any law that the province actually enacts. And what does that do? Well, that gives the judiciary and the federal government carte blanche over what legislation they want the provinces to actually enact. And we've seen some legislation out of Alberta that tries to protect the province from some of the overreach from the federal government. That would be undone at the snap of a finger if this actually were to be found to be valid, and the Supreme Court agreed with Sean Fraser, Mark Carney, and the federal government.
Right. So whether or not Sean Fraser and the rest of the Liberal government realize this or not is kind of irrelevant. What they are doing is causing a constitutional crisis.
And what's a constitutional crisis?
Typically, a constitutional crisis is when something written in the Constitution doesn't really... The laws of the land don't match up with what's in the Constitution. So in this case, we have Section 33 of the Constitution, the notwithstanding clause, and then you have the government able to just override that.
Right, and let's follow that through and see what would happen. So let's say the Supreme Court says Ottawa's right, and this invocation of Section 33 of the Charter of Rights and Freedoms is actually invalid. Okay, now let's imagine that Quebec ignores that and they maintain the ruling of Bill 21 anyway. what now? This is the crisis.
Yeah.
Because it's effectively a constitutional paradox where the provinces are saying one thing, the judiciary is saying another, and Ottawa is saying another. There's no other place to go to appeal because the Supreme Court has already made their ruling. So now you're nowhere.
Right. You have these three different branches of government, whether it's at the federal level or the provincial level. They don't agree with each other. They're all there to create laws, and they are, in a sense, overruling each other. So who has the authority?
Right. And this is the tricky part about this, because whether or not you agree with Bill 21, that's a smaller issue here in terms of the actual Constitution itself, because the Constitution has operated this way for 43 years. And Quebec itself has used the notwithstanding clause. I think it's around 13 times. Ontario has used it recently, and there's been 0 challenges. Other provinces have talked about using it, but just because you're talking about using the notwithstanding clause or threatening to use it, that's not a reason for Ottawa to say, well, none of you can use it now. That's not how this was actually intended to work. This was intended to work this way to maintain the balance of power between the three bodies. So this is where Canadians should get very concerned, because the more that the federal government tries to consolidate power in Ottawa, the less ability to fight back we will actually have. And this can be interpreted as an attack on the provinces. Now, here's the good news, folks, and it's really good news. Mark Carney has talked about uniting the country. Well, this is doing so in a way that he probably didn't expect, because Ottawa isn't the only intervener on this. You actually have the Attorney General from British Columbia, from Alberta, from Manitoba, from Saskatchewan, from Ontario, and you'll probably hear some more from New Brunswick, PEI, and the rest of them. But you probably already know that all of those provinces have different parties governing them. But they all agree. They all agree that this is a blatant overstep and overreach by Ottawa. And they are fighting for the province's ability to actually continue to use Section 33 as it was intended and as it has worked for the last 43 years. Now, what's the most likely scenario here? Well, the most likely scenario is the Supreme Court, regardless of who they were appointed by, doesn't really want to cause a constitutional crisis. So what they probably will do, if they know what's good for the country, is they will probably say the invocation of Section 33 here wasn't appropriate. However, we are not going to invalidate the invocation of Section 33. And we will just essentially say what the other court did about the Emergencies Act and say, naughty, you shouldn't have done that, but we're not going to get in the way of the Constitution and completely destroy the separation of powers within our country. And it's a little ironic that Sean Fraser is taking this stance on this. Why? Because as the Attorney General of Canada, he actually has the power to rescind the appeal of the Emergencies Act decision that actually went through the federal court and found it unconstitutional.
But of course, we can't have that.
Because, only the federal government can be seen as operating completely correctly. But this is actually, it's in line with how separation of powers is supposed to work. In this case, the court said, you know what? We've reviewed the challenge by the organizations that actually brought the challenge forward. We agree with that. It was unconstitutional, but that's as far as it goes.
But isn't the local party the party of protective charter?
That's what we're led to believe. So it doesn't really matter what you think of whether Bill 21 was right or not. That's a separate discussion. What matters is the way that the country has been set up to operate in this way that separates the judiciary from the legislative branch, from the executive branch, has worked since 1967, and the Constitution has worked for the last 43 years. Somewhat. The Emergencies Act would call that into question. However, this is where you have to allow the provincial autonomy and the provincial courts to operate in the way that they do. And if the people don't like a law that actually was put into effect, they are completely free to vote out that government and put in a new one. So this is where this is coming to a head. But this has the potential to cause a national crisis if the Supreme Court actually does agree with Ottawa. All hell is going to break loose, and it's going to break loose rapidly.